Hi, this is Laura Shantz. We are talking about children and divorce, family law, custody, and parenting time cases, and I want to talk to you about representing children. How do you get an attorney for your child? Well, one of the ways that you can guarantee an attorney for your child, especially in the state of Oregon, is to have your child write a letter asking for an attorney. Under the Oregon statute, if your child writes a letter asking for an attorney, your child is going to get an attorney for sure. But another way, especially with younger kids, is if you are in the middle of a divorce or other family law case and you write a declaration about the reasons why you think it would be helpful for your younger child to have an attorney. And there will be a motion given to the judge with your declaration, and the judge will decide whether your child should have an attorney. And likely the judge will say yes. So you can't just say, I want this attorney for my child, and go find the attorney and go have the attorney meet with your child. You have to do this all openly. You have to talk to the other party and or the other party's attorney. If you have an attorney, both of the attorneys and the parties have to agree who the child's attorney is going to be. And then you can ask for that attorney to be appointed. But it has to be a neutral person who hasn't talked to your child in advance, that everybody agrees on. So that's how it has to happen. What is the difference between a best interest attorney and an advocacy attorney? Typically, children who are over the age 12 are going to get an advocacy attorney. And what that means is, ethically, when you're an attorney representing a child and they're over age 12, you have to represent them based on their wishes. So no matter what their wishes are, if you personally don't think it's a good idea, if you personally don't think it's in their best interest, you still have to advocate for what they want because of their age. Now, if it's a child under the age of 12, you don't advocate always for what they want. You listen to what they want, you take what they want into very great consideration, but you can advocate for what you think is in their best interest. So that's the difference. And 12 is just a basic guideline, but sometimes children that are 12 are very immature, and you could still ask the judge to allow you to advocate best interest. Or sometimes children that are age 10 are very mature, and you can ask to advocate for what they wish. So what does the attorney for your child do? Well, the attorney is going to meet with your child in private and talk to your child about a lot of things, their feelings about, usually it's related to custody and parenting time and what kind of a parenting plan they may want. The attorney can help try to resolve things by helping mediate, by talking to the parties after the attorney has heard what the child is saying and recommending a resolution to the case. So the attorney's major role is to be a voice for your child, so your child does not have to go to court. The attorney can let the judge know what your child wants, can let the attorneys know, let the parents know, and tell the parents and attorneys what the child's attorney will recommend to the judge, and hopefully will resolve the case without having to go to trial. Thank you.